Okay, welcome back to the third and final panel of our program today on scheme liability, Section 10B and Stoneridge Investment Partners versus Scientific Atlanta. We've looked at the law surrounding liability under 10B and when secondary actors can be liable legally or can or should be liable for securities fraud. We've talked about some of the policy implications for investors, for competitiveness, perhaps for firms that have to comply with Sarbanes-Oxley and other regulatory requirements. And in some respects, these are precursors to looking at the actual case itself of Stoneridge Investment Partners versus Scientific Atlanta. And we're very fortunate to have with us today to debate the merits of the case two attorneys that are involved in this case representing amici on the respective sides of this litigation. Taking the side or standing in for the plaintiffs, we have Eric Allen Isaacson, who's a partner at Coughlin, Stoia, Geller, Rudman, and Robbins in San Diego. He is on the team of attorneys who filed the petition for certiorari in the Enron Securities litigation, a petition for certiorari that's been pending for some time, and I think many observers believe is being held by the court pending the outcome of the Stoneridge case. Also filed an amicus curiae brief supporting the petitioner in this case, as well as in the related case, the Simpson versus AOL Time Warner case that we've heard about earlier today. On this, standing in for the defendants in this case is Ashley Parrish, who's a partner at Kirkland and Ellis in Washington, D.C., and he also worked on an amicus brief in this case. In his case, a brief filed on behalf of the Washington Legal Foundation, arguing against finding scheme liability in this case. What our format is going to be is that each of our debaters will have 10 minutes initially to make their initial case. Then they will each get 5 minutes of rebuttal, and then at that point we'll follow with questions and answers from the audience and I suppose from me as well. And certainly it's an opportunity for all of you, those of you that are here and those viewing the webcast, to play the role of Supreme Court Justice. And if you had the attorneys in front of you arguing this case, what do you think are the key questions that the court needs to have answered in deciding how this case should come out? So without any further ado, I will turn the podium over, or the microphone over to Mr. Isaacson, who has 10 minutes to lay out the case for the plaintiffs.
Thank you very much. The basic question presented by the case is whether one who participates in a scheme to defraud investors by executing sham transactions in order to falsify a publicly traded company's reported financial results, does that person thereby commit a manipulative or deceptive act within the meaning of Section 10B? Now, the facts of Stoneridge involve vendors. Charter Communications was a company that needed to, it felt, post revenues that analysts were expecting of it. It was buying television set boxes for the top, digital boxes, and it went to the vendors that were selling those boxes to it and said, hey, charge us $20 extra for each and every one of those. We will structure a transaction where it makes it look like we've got a legitimate business relationship going on here where we're going to give you advertising and backdate the documents so that it looks to the accountants that this is a legitimate transaction rather than something that's just to pad our revenues, and got them to go along with this. Now, the consequence of this deal was to inflate the revenues of Charter by $17 million. That was the purpose. That was why these sham transactions were entered by Motorola and Scientific Atlanta. Now, that's a case where third parties engaged in sham transactions in order to inflate the reported financial results of the company. Another case where outsiders engaged in sham transactions to hide debt and inflate reported financial results is the Enron case, which has come up several times today. Now, in Enron, the fraud consisted of hiding Enron's debt. The fraud consisted as well of forming bogus transactions to make it look like Enron had much larger revenues than it really did and much higher cash flow. Now, who did that? The fact is that Enron's bankers did it. Credit Suisse and Merrill Lynch structured transactions, executed transactions in order to hide debt and inflate financial results. And they were quite successful at it. Now, Steve Bainbridge, a few minutes ago, said that in cases of securities fraud, you ought to go after the people who actually are responsible for the wrongdoing. In Enron, that's the third parties. It's Credit Suisse. It's Merrill Lynch. Now, the question again is whether engaging in that kind of conduct is manipulative or deceptive. We've been told many times today that you've got to start with the language of the statute. Section 10b prescribes manipulative or deceptive devices or contrivances. Is it manipulative or deceptive to engage in sham transactions to phony a company's financial results? Well, I think it is. 30 states, more than 30 states, represented by Andrea Sight and the Ohio Attorney General, filed a brief saying, you bet that's manipulative and deceptive. The SEC said, yes, that's manipulative and deceptive within the meaning of 10b. And they wanted to file a brief. And the Bush administration said, not so fast. You are not going to come in this case on the side of investors who are victims of fraud. You might ask why the Bush administration takes that position. The Solicitor General ultimately filed a brief that said, well, yeah, that's manipulative. It's deceptive. It violates Section 10b. But people who violate 10b by committing a fraud that causes millions and millions and millions, or in the case of Enron, billions of dollars of losses, shouldn't necessarily be liable. Because if the $17 million that Motorola and Scientific Atlanta generated with the sham transactions was included in Charter's financial statements, according to the Solicitor General of the United States, only Charter should be liable. Only Charter committed a manipulative practice upon which the public relied. Well, I got to tell you that $17 million was what was relied on by the public. They looked at the financial statements and thought that company, Charter, was making more money than it was because of the manipulative and deceptive conduct of the vendors, Charter and Motorola and Scientific Atlanta. Now, the Solicitor General, and let's go to Enron, the Fifth Circuit as well had to agree that the kind of conduct that was at issue in the Enron case was both manipulative and deceptive. Well, not manipulative, but was deceptive as that word is used in section, or as that word is used in ordinary language, in ordinary speech. They also acknowledged that as a matter of fact, the market relied on the manipulation and deception that was conducted by Enron's investment bankers. Now, the court nonetheless ruled for the defendants in that case, saying that it was by losing sight of the limits that the statute places on Rule 10b-5 and by ascribing natural dictionary definitions to the words of the rule that the district court and like-minded courts, such as the Ninth Circuit or Parmalat District Court, have gone awry. Reading the statute as it was written by Congress was the mistake that the district court made in Enron, according to the Fifth Circuit Court of Appeals. The court explained, and I want to go on here, on page 389 in 482F3rd, that defining deceptive by referring to the same dictionary the Supreme Court used to define device in Ernst & Ernst against Hochfelder, the approach taken by the district court in Parmalat and approvingly cited by the district court in Enron is improperly to substitute the authority of the dictionary for that of the Supreme Court. Well, the Supreme Court has consistently said, start with the statute's words. Start with those words' natural meaning. It said that in Ernst & Ernst against Hochfelder when it went through the 1933 Webster's Dictionary, looking at the meaning of the specific words in Section 10b to say those are words that imply deliberate fraudulent conduct. So you can't have liability for negligent misrepresentation. The Fifth Circuit looked at cases dealing with liability of outsiders for insider trading, where they hadn't said anything misleading, hadn't done anything to mislead anyone, and said that, well, for insider trading liability, you need to have a duty. And the Fifth Circuit said, well, no breach of duty, no liability. They said, Fifth Circuit said, and I'm quoting now from 482 F. 3rd at page 383, the plaintiffs are likely correct that the market for Enron securities was efficient, and that inherent in that conclusion is the fact that the market price reflected all publicly available information. But the factual probability that the market relied on the bank's behavior and or omissions does not mean that the plaintiffs are entitled to a legal presumption of reliance. It's clear the statute, by prohibiting manipulative or deceptive devices or contrivances, outlaws engaging in deception that is designed to mislead investors. And it's only by coming along and saying that there's no direct reliance on this, or that there's no duty not to deliberately mislead investors, as the Fifth Circuit did, that, in my opinion, you can avoid a finding of liability and a reversal in the Stoneridge case.
Let me start a rebuttal to that, but before I do that, I should really just let everyone know that I'm not here on behalf of my client who I filed the brief on, but really just on behalf of myself, and I do appreciate being able to share some thoughts. What I think we'd start off is maybe the points of agreement that we have, but what I think we can do is, before I even get to the points of agreement, begin with simplifying the question presented, because it's a long-worded question presented, but it's really actually even simpler than that. The real question is this actionable securities fraud within the definition of Section 10b? So we can put to the side the fact that we can agree that this may or may not be wrong, it may or may not be misconduct, and it may or may not be punishable. But the question before the Supreme Court is a question of, is this securities fraud or not? And where I come out on that, this is a question for Congress to decide, not for the court. And there's a number of reasons why Congress itself has chosen not to take the added step of making these sorts of cases the types of cases that can be brought under Section 10. And in doing that, Congress has been wisely, or should have been wisely, concerned both with the fraud that we see outside of the system, the fraud that's been alleged to have occurred here by charter and by the vendors, and the fraud that we see inside the system, which are lawsuits that shouldn't be filed that impose enormous costs on investors. But what I said at the start is I wanted to point out the ways in which we agree. And I do agree that we need to start with the text, and the text here is very helpful. But where I disagree with Mr. Isaacson, and also disagree with the petitioners in this case, is that you have to read the whole text. It's fine to invoke principles of reading the text, but you have to read the whole text. It is true, and I agree with Mr. Isaacson, that we can define the terms of deceptive conduct fairly broadly. But we need to look at what comes before that. And it's key at what comes before that is that what it says, the statute says, any person may not use, and I'll skip the instrumentalities of interstate commerce, mails, and so forth, to use or employ in connection with the purchase or sale of any security. And then it goes on to talk about deceptive device. So there's a few words in there that are very key. One, the key word is use or employ. You have to look at that. Second, we have to look at the fact that it's a security, and it has to be done in connection with the purchase or sale of that security. So we're not just talking about fraud. We're talking about security fraud. Now here, what we have is fraud relating to set-top boxes, not fraud relating to securities. And I know that the Supreme Court in other cases has interpreted the in connection with requirement fairly broadly to talk about coinciding with. But we're not talking about anything here that coincides with security fraud either. The facts are pretty clear, and it's undisputed that vendors accounted for the transactions correctly. They had no control over Charter's accounting itself. They had no contact with Charter's auditors. They weren't influencing Charter's auditors. They made no statements to the Charter investors themselves, and they owed no duty to those investors. And I think those are dispositive here, because what we're talking about, again, is a question of securities fraud. Now, along with those lines, in addition to the plain text, and I think coming out of that plain text, you have central bank. And central bank recognized that in addition to satisfying the fact that this is in connection with the sale of a security, you also have to satisfy normal standards of showing reliance and causation. Here again, I think the petitioner falls down in not being able to make those satisfactory standards. Again, the vendors did not communicate with the charter's investors. They did not talk to the investors about the documents relating to set-top boxes. There was no statement directed to the market at all, and there was really no inducement here for charter to make those misstatements. Now, I think the piece of information that's most important about this, that again, I think really confirms both what the court did in Central Bank and the respondent's reading of the statute, is what happened in 1995. And a lot of this was talked about this morning, but Section 20E is really, I agree with Professor Bainbridge, I think it's dispositive. Congress had a choice as to whether it was going to open this up to private lawsuits, and it said no. It said we're going to leave this within the SEC and allow SEC to enforce these. Now, Congress may have made the wrong decision, right? It may be that we need more enforcement here. It may be the case that we think that the SEC's penalties are not enough. But that's a choice that Congress has to make. It clearly knows how to make that choice, and it made a deliberate choice in 1995 not to open this up beyond the SEC. If Congress wants to change its mind, it's free to do that. And then I think lastly we have to take a look at Central Bank. I actually disagree with most of the panelists this morning in the sense that I do agree that Central Bank is easily distinguished on the facts. But and maybe it's just my own shortcomings, but I don't see how you distinguish Central Bank aiding and abetting liability from any other form of secondary liability that we're talking about here. And what I mean by that is that, and you see this very clearly in the petitioner's briefs, they cannot distinguish between aiding and abetting on liability and the secondary liability they're opposing here, except for to say that the difference is some deceptive device. But I'm not sure what a deceptive device would be here that was any different from the deceptive device that would give rise to aiding and abetting liability. So I think the distinction at the end is a linguistic one. And maybe there's some weight to linguistic distinctions, but I don't see this linguistic distinction really carrying much weight, particularly in light of what Congress did in 1995. So if you take a look at that, the question is, well, what's the response? And I think Mr. Isaacson let it out very well. He starts off by saying that the purpose here was to defraud charter investors. But that's not really true, is it? In the sense that I don't think there's anything in the record, and there's certainly nothing was pleaded, to suggest that the vendors were engaged in the purpose of defrauding charter investors. What the vendors were engaged in doing here was entering a very favorable transaction for them that allowed them to get extra advertising. Now, we may think that was fraudulent. We also may not like the way that they handled it or any of the backdating of the books and other allegations that were made. But I don't think that we can say that there are sufficient allegations here that was going on is that when they entered these transactions, the whole point was to defraud charter investors. It wasn't. It was to engage in arm's-length transactions. And I think at that point it's helpful to think about a clear rule here that applies and makes a whole lot of sense. And the rule is as simple as this, is that if you are engaged in an arm's-length transaction for goods and services with somebody who happens to be in the securities business, no liability. That's it. Don't need anything else. If Congress wants to change it, that's fine. But we do not want to set up all of the companies that might engage in business from the smallest to the largest transaction and make them now responsible for being watchdogs for security violations. If we want a watchdog, we've got the SEC to do it. Or we can enact other laws by Congress. But courts shouldn't be getting involved with suddenly appointing all of these companies to engage in the very expensive and costly thing of not only figuring out whether their books are proper, but also whether the companies that they do business with. And that really is the point here, that there's nothing to show in the record that either of the vendors here cooked their own books. It was the vendors complied with their accounting obligations. It was really only charter. And then just a couple of things to finish off without going too far here. But one is the SEC. There's been comments about the SEC, and it's significant that the SEC wasn't allowed to file a brief in this case. I think there's two responses to that. One is that it's not surprising that the SEC here has some institutional conflicts of interest in terms of how they want this statute interpreted. Also, it's not at all surprising that the Solicitor General will take a different position than the SEC. This happens all the time. But I also don't think that, holding all those things aside, that the SEC is deserving of any deference here. It would be one thing if you asked the SEC how to implement their particular regulation in the context of an enforcement proceeding where the SEC is involved in. In that case, yes, the SEC gets typical deference, maybe Skidmore, maybe Chevron, depending on where it's happening. But in terms of actually asking a question of whether there's an implied right of action here, I don't think the SEC gets any deference at all. And so there's no reason for us to be worried about the SEC. And I think the fact that the court rejected the SEC's views in the earlier Supreme Court cases, primarily Central Bank, is a good example that doesn't really matter what they think here. And then finally, there's Enron. And I have to tell you, I've not been involved in the Enron case. I'm sure my firm represents clients that have an interest in that case. I don't know much about the case at all. But what I can tell you is that it seems to me that bad cases make for bad case law. And B, the issues in Enron are not at issue here in this case. It's a different case. What we're looking at here is simply the question of the third-party vendors. We don't need to get into questions of whether there's additional duties that may arise. And again, I just don't know what's going on in Enron, but I just think that we need to focus on what's going on in this case, and there's a clear rule in this case that needs to be set forth, and that rule is, as I said before, that if you're a third-party vendor and you're not engaged in the sale of securities or engaged in conduct that's in connection with the purchase or sale of those securities, then there can't be liability under the securities laws.
Okay. We may think that it was fraudulent, but if it was fraudulent conduct undertaken by the vendors with the purpose of generating phony revenues to mislead investors, it strikes me you're right within the literal meaning of Section 10b. If you want to talk about what Congress did in 1995, what it did was to set up a bunch of requirements for the implied cause of action under Section 10b, requirements for what plaintiffs have to plead, for what plaintiffs have to prove, and it also set up requirements for proportionate liability. Congress recognized that a scheme to defraud is the typical securities fraud, and that multiple participants in the scheme are going to face liability together. That's precisely why there are specific provisions in the 1995 legislation for proportionate liability and for allocating liability. There are also provisions with respect to contribution. Now, when it comes to the question of reliance that the Solicitor General ends up hanging his hat on, it strikes me that reliance has always been a question of causation. In fact, the Supreme Court said in Basic against Levinson that there's more than one way to show reliance. If the vendors engaged in a scheme to inflate a publicly traded company's revenues by $17 million, and that is reported to the public as everybody involved in the scheme expects it to be, I don't think that the fact that the company reported the phony revenues as contemplated is an intervening cause that cuts off reliance. The reliance is of investors on the reported results. They don't have to know about the specific transaction. And according to Basic against Levinson, people who purchase in the open market at an inflated price don't need to know about the specific statements that produce that price. Now, folks sometimes talk about Basic against Levinson being some kind of a radical deviation from the common law, but I find its principles laid out by Professor A.A. Burley, a professor at Columbia Law School and a member of Franklin D. Roosevelt's Brains Trust, in a law review article he wrote in 1931 in volume 31 of the Columbia Law Review, Liability for Market Manipulation. The principle goes back even further, a market manipulation consisting of creating a false impression in the marketplace, the seminal case being Rex or the King versus de Beringer, King's Bench, 1814. The crime in that case, the wrong in that case, was spreading false rumors that Napoleon Bonaparte had died in order to inflate the securities markets in England, a long time before anyone had come up with an efficient capital market hypothesis. And the King's Bench ruled that that is a fraud on anybody who had transactions in the markets at the time that the prices were inflated. It goes back a long way. It's got deep roots, and quite frankly, it's got roots in the common law. Common law fraud, according to Passley against Freeman, often recognized as a seminal case. King's Bench, 1789, three-term reports, I think, said that any time one person commits deceit to the damage of another, an action in the case for deceit lies. The elements of fraud that have been produced since then are all aimed at connecting or ensuring that there's a connection between deceptive acts and a damage, which is exactly what we've got in a case like Enron or a case like Stoneridge. You go on to the statement of what is fraud. The Supreme Court in Wyoming Ranch Cattle Company in the 1800s said it consists of deliberately producing a false appearance or a false impression, and it doesn't matter how it's done, whether it's by words, by acts, whatever. We have in Stoneridge vendors who endeavored to inflate a company's financial results with phony transactions and backdated documents with the effect that the phony results will be reported to the marketplace, inflating the market price. You've got all the elements of a securities fraud there. You've got reliance when people purchase at the inflated price. I think it ought to be a slam dunk for petitioners. But the fact that so many academics have said they think it's going the other way gives me some cause for concern. Perhaps that underscores Professor Bainbridge's argument about institutional incompetence at the Supreme Court. I would think that they would be competent enough to see that this is fraud, plain and simple, and that the plaintiffs ought to be able to proceed.
So I think it's important to start where Mr. Isaacson focused on, right? He didn't start off by focusing on what it means to be securities fraud, but he instantly said, his first sentence, the purpose here was to mislead investors. Well, there's two problems with that, right? It's either the problem that the purpose to mislead investors itself is nothing that happened that actually the vendors did. They didn't engage in a purpose to mislead these investors. Or you could actually plead something like this, but then the problem is, what sort of pleading standards do you require in order to stop cases from moving on to a litigation and past the initial stage? The problem here is you can always allege that there's a purpose to lead investors in a case like this. But really, there's no evidence to suggest that's the case. Even if you accept all the allegations relating to the backdating, even if you accept all the allegations about going back and forth, that isn't showing that Motorola or the other vendor was actually engaged in the purpose of misleading the investors. No, they were engaged in a very favorable transaction for themselves that they engaged in, and they reported it properly on their books, and they complied with the requirements for doing so. But so the problem here is how do you police being able to plead these sort of security class actions? And the problem is, I think the standard that Mr. Isaacson would want is just far too liberal. It allows too many of these cases to come in. But then maybe the response to that, which is what I thought I heard in sort of his plea, is that we've got these consumers out there or these investors that maybe aren't doing so well. So what we should really do is, no matter what, more liability is better. And I think this is a standard misconception, but if you feel like you want to protect the investors, then greater liability standards has to be the way to do it. But that's just wrong. It's not only wrong because it's wrong as an absolute matter. There has to be something that is an ideal level of enforcement, not too much, not too little, and we should figure out what that is. It's also wrong as an empirical matter here for all the policy reasons we talked about this morning. Trying to refund investors in this mechanism is just a really bad way to do it. Transaction costs are far too high. You've got consumers at the end of the day, I think, are worse off, not better off because of this. And what you end up having is you have a civil justice system that really is spinning out of control. So I finish off where I start, which is that it's really up to the Supreme Court here to put an end to this type of litigation and let Congress decide how it wants to handle it. If that means expanding the SEC's authority, that's fine. If it means creating some other form of private liability, they can decide to do that, but that isn't the job for the court.
Okay, we're now going to go to questions and answers. Again, if you are watching this on the webcast and you want to email a question, you can email that question to kcblr@gmail.com. I'm going to take the moderator's prerogative to ask a couple initial questions. The first question is for Mr. Parrish, and in your initial remarks, you made a bunch of comments about the importance of the language of 10b and the connection to securities. And I'm wondering if the rule you're suggesting the court should adopt would suggest that there is a meaningful difference in the liability exposure for, say, a Motorola or a vendor that's selling a product like a set-top box, and, say, Credit Suisse, Merrill Lynch, firms that are actually involved in providing financial-related services to other companies. In your rule, are those sorts of companies more likely to be subject to liability than, say, a Motorola or a Scientific American?
Well, and I have to tell you, I think it gets, the more you move along the fact pattern, it becomes harder to know where the line drawn. But the line is clearly far away from where it is here. So I do think that it's more likely that companies that are engaged in not clearly arm's length transactions like this, there's a greater possibility that there might be liability. But it's going to depend on the facts. And again, you still have to show that it was in connection with the sale of security, and it would still have to be within the framework that central bank lays forth. And so my suspicion is, if I knew more about all of those cases, that there's definitely the case that the plaintiff's bar is arguing for too high a liability standards. That seems like a pretty safe guess. But where the actual line is, I don't know.
I guess, but in your view, would say a broker or a banker or an accounting firm that is involved in some way in the financial activities of a company, wouldn't it be easier to argue that their activities, whatever they were, or their services, whatever they were, are in connection with the sale of a security, which, as you argued, would be a requirement for litigation of this sort?
Yeah, I mean, I think there'd be other problems, but it could well be the case that those sorts of actions are more likely to be in connection with, where these are not.
For Mr. Isaacson, in your remarks, you talked a lot about the common law of fraud and what the traditional understanding of fraud has been in common law, but one of the things that was discussed earlier is that for good or for ill, Congress has displaced the common law causes of action for fraud with this securities law regime. And I'm curious how you respond to the argument that given that Congress has displaced this, it's not really helpful to look at what British courts were doing 150 years ago, and not very helpful to look at the common law of fraud because, again, for good or ill, Congress has created this regime and more recently expressed its quite explicit intent to crowd out or displace or preempt state law causes of action that would be directly grounded in the common law.
Well, Congress chose in 1934 to draft a statute that spoke about manipulative or deceptive devices or contrivances. Deception is a common law concept in the law of deceit or law of fraud. Manipulation is something that I've heard a number of people, and it's, throughout the briefs filed before the Supreme Court in Stoneridge, is limited to isolated market transactions, wash sales, matched orders, that sort of thing. But if you step back and look at the history of what manipulation meant in 1934 when Congress passed the statute, that was very controversial. That was a position that English courts had adopted in Scott versus Brown, and that the United States Supreme Court, in a footnote, I believe in the Burlington Northern opinion, acknowledges was an extension of the law of market manipulation, which already existed, to hold that in addition to false statements and false rumors, market manipulation includes deceptive acts, wash sales and that sort of things, deceptive transactions that create a false impression in the marketplace. Now, if you look at A.A. Burley's article in 1931, you'll find that the established law of market manipulation that was non-controversial was the idea that feeding misinformation into the marketplace affected the market price. And he articulates what I identify as the fraud on the market doctrine and fraud on the market principles right there. He goes on to argue that market manipulation ought also in American courts to encompass matched orders and wash sales and that sort of thing. And he follows up with an article in 1938 saying, I told you so, they're doing it now, citing United States versus Brown, a case that did it, I think, under the mail fraud statute in 1933, district court opinion. I think that you can look at these, common law background to ask, what does manipulation and what does deception mean? And the basic goal of the law of fraud has always been to say, is somebody doing something with the purpose or the intent of causing somebody else to be misled and to rely to their detriment? And I think we've got that. I don't think that Basic against Levinson is a radical departure from those principles in all honesty. Now, is the court bound by common law? No, it's not. The court can frame Section 10b liability in a number of ways that are deviations from the common law. But I think it's also important to look at the fact that the United States Congress in 1995 pretty clearly endorsed the existence of a 10b cause of action. It pretty clearly endorsed joint and several liability and proportionate liability, recognizing that there are going to be multiple actors and that when there are different actors working together in a scheme to the common end, as we've got in both of these cases we're talking about, you look at the character of the actions and their connection to the losses ultimately sustained. Congress has spoken, and it's not up to the courts, in my opinion, to overturn a liability that Congress has basically recognized.
Questions? Professor Painter, if you just wait for the microphone. Oh, since you're closer, we'll get Professor Bainbridge in first.
I'd like to pose a hypothetical for both parties, if you don't mind, and maybe Mr. Parrish first. I'm a consultant, and I come up with an idea for one of these round-trip transactions, and I package it. I devise how it's to be done. I lay it out. I've got PowerPoint slides that show the executives exactly what to do. And I go to the company and I say, look, here's the deal. Here's how you do this. And they're like, well, isn't this going to be illegal? And I say, yeah, but you're never going to get caught, and yada, yada, yada. And look at the good stock price effects. And they say, okay. And they do it. Nobody has ever heard of me. None of the investors have ever heard of me. The only time my involvement comes out is years later in a deposition. One of the executives of the company who's being sued by somebody like Mr. Isaacson in his deposition says, well, we got the idea from Bainbridge. And all of a sudden everybody's like, wait a minute, who's Bainbridge? Where did he come in? Is there any way that I deceived the investors of that company? Perhaps I conspired to help deceive them. But is there any way that I, in your view, the test that you've articulated, would I be held liable? And then I would ask Mr. Isaacson maybe to address the question of whether, in his view, that's an appropriate case for 10b-5 liability, and if so, why?
Yeah, I guess there's a couple of things to respond to there. I think the key point that your hypothetical does is show why this case should be an easier case. So I think just to point that out is it really shows the difference there between a situation where there is really in connection with a sale or purchase of a security, because it clearly exists there. And that's, I think, really helps show why this case is an easy case and should be easily decided. But the question I think that your hypothetical drives at then is really goes further is to the issue of reliance. And I actually don't know the answer to that. I actually, in taking out a role of the debate of the person before the Supreme Court, I actually think the reliance issue is not the way that the case should be decided. I think it's another arrow in the respondent's quiver. But I really think that the arm's length transaction vendor point is the issue here. And then when you have situations where you have collusive behavior there by consultants that are providing specific advice, that's a very different case. And I have to be honest, I don't know enough about the securities laws as to how you'd actually find a way of enforcing that. And if you can't, like you pointed out in your morning comments, those are the types of actors we should be going after. But I don't know how you do it, but I do know that it wouldn't fall into what this case is about at all, and you don't need to decide this case in a way that would preclude you from looking at those types of actors later. So I know that's not really a complete answer, but unfortunately it's as much as I can do.
Mr. Isaacson?
With respect to in connection with a purchase or sale of a security, financial reports are reported on a quarterly basis in SEC filings precisely so that investors can rely on them in connection with purchases and sales of securities. The SEC requires them to be audited so that they will be reliable when investors rely on them. And the case of Stoneridge is one in which documents were backdated to give either the auditors cover or to mislead the auditors so that the phony numbers would go into the financial reports and be relied upon by investors in connection with the purchase or sale of securities. So I think in connection with purchase or sale is pretty clearly satisfied there. With respect to your hypothetical about somebody who basically designs the round-trip transaction for it to be executed by a company, yeah, I think they're part of the scheme to defraud and think that they ought to face liability, assuming the round-trip transaction is in fact executed and the results are reported and mislead investors.
I'm wondering if we could, I want to give you a slightly different hypothetical. I don't, Mr. Isaacson, I want to know how we would resolve this one. Let's say my cousin works is a salesperson for a publicly traded company, and he's having a difficult time meeting his sales figures, and he and I figure out some way, whether it's designed by Professor Bainbridge or whomever, but some way that I can help him inflate his sales figures because I don't want him to lose his job, and I care about my cousin, and that's something. And what I'm doing is clearly wrong. I'm helping him defraud his company, and as you know, if his sales figures are inflated, that's going to inflate the sales figures of this publicly traded corporation, and it therefore is going to result in false information being communicated to investors that investors may in fact rely upon in making transactions. Clearly, I may be participated in a fraud, but is your position that what I've done is in connection with the purchase or sale of securities merely because my fraud has some economic effect that is going to alter document or alter the reporting of documents that investors may in the future rely upon?
Well, in California, we've codified maxims of jurisprudence, and one of those maxims is that a person is deemed to intend the natural consequences of his acts. If you are doing something that is a deliberate fraud that you know is going to have an effect on the company's financial results that are reported for investors to rely upon, yeah, I think you've committed securities fraud.
So when I help my cousin, I'm not only defrauding his employer, perhaps, I'm also defrauding the employer's investors and violating 10b.
Well, you're asking me to assume that you and your cousin are working together to falsify the company's financial results to a material degree for whatever motivations. The motivation may be to save his job or get him ahead of the company or something like that. But as soon as you talk about inflating the company's reported results to a material degree, you know those are going into public reports, and that investors are relying on that. You know, as a publicly traded, employee of a publicly traded company, that it's got a stock. You probably know the stock price, and you've got a darn good idea of what contributes to that stock price.
Jonathan, can I jump in here?
Please.
This highlights what they say on page 3 of the reply brief in the petitioners. The only thing that they say to try to draw this nexus that you're trying to draw here is that what is important is that respondents anticipated that the phony figures would be disseminated by charter and certified by its auditors. I think that's what your question goes to. But if that's all that needs to be alleged in order to do Section 10 liability, there's no preventing anybody from ever alleging this type of fraud. I mean, you don't need, even those who find it helpful to think about the fact that there's been cookbooks and so forth and backdated statements, you don't need any of that. All you need to now do is allege that there's an anticipation that this would lead to phony figures. I just don't see how there's any connection there at all without basically wiping out what central banks stood for, which is there has to be a limit to what securities fraud is versus just fraud.
What about in this case? I mean, Motorola and Scientific America are offered this sweetheart deal by charter, right? We're going to essentially give you free advertising or super discount advertising if you help us cook the books. Is it unreasonable to say that someone at Motorola and Scientific America is smart enough to know that the reason for this is not because Charter Communications is feeling particularly charitable or really cares about their having more advertising, but because someone at Charter Communications is trying to provide a misleading picture? I mean, shouldn't we assume that, particularly in the case of companies like Motorola and Scientific America, these are sophisticated players. They understand that the deal that may be too good to be true is too good to be true for a reason, and they know what that reason is. And if that's the case, is it really casting too broad a net to say that they're going to be held responsible if in fact that leads to some sort of fraud?
Yeah, I think it is. I mean, I think there's three things there. One is that I think it is true that you could imagine situations where certainly somebody in Motorola may have known. But this just goes to the points this morning. You've got these large entities with thousands of personnel to them. And so the question is, assuming that there may be something like that, how far do you want to extend the liability rules? And what makes sense? And the truth is that you can easily now come up with assumptions as to why any company might have perhaps known about these things. But I think built into your hypothetical is the assumption that this is sort of a bad deal. And I think there's some truth to that you look at these set-top boxes and you go, well, this doesn't make a whole lot of sense. But at the end of the day, from Motorola and the other Scientific, whatever name was, those two companies, this was not a bad deal. This was an advertising agreement. They got $20 extra. They got extra free advertising. And you would essentially be clamping down on all of those types of favorable transactions and forcing companies to engage in sort of over-the-top analysis to see whether anybody at some point might consider that this turns out to be something that would allow somebody else to cook their books. So I think it's not that you can't at some point trace something out. It's just at some point you have to say, well, the security laws only are supposed to go so far, and they're not supposed to go this far.
Emphasized that the vendors here did not have the purpose of defrauding investors. What if they had? What if introduced at trial were email from the vendors back to the company the issuer saying, well, we know what you're doing here, but that's between you and your investors. That's not our problem, cite Central Bank of Denver. CC to their general counsel. It seems to me they'd be acting with the purpose of defrauding investors. Should they be liable? And if the answer to the question is yes, in that circumstance they should be liable, whereas in this case they should not, can't this case be thrown out under the Cyander standard and focus on Cyander? And the same thing with Central Bank. Couldn't Central Bank have gone the other way, have said fine with aider and abettor liability, but the aiders and abettors better have knowingly participated in the fraud?
Yeah, I would answer no, yes. I was using the purpose point as a way to illustrate what I think the petitioners are doing in this case, which is confusing the facts to make it different. But I would still believe that the correct rule is that you don't need to look at purpose at all. If it's honestly an arm's length transaction, if it's not an arm's length, that's different. But fraud doesn't define whether something's arm's length or not. If it's arm's length transaction, in which case it's not involved in the sale or purchase, I think that's the end of the issue there. So to your first question, I'd say no liability, but I think it helps the fact that there's no purpose here. To your second question, I agree that as an alternative grounds, you can look at these issues of scienter or reliance and so forth. I just think that gets messy, and it gets messy in a way that sort of goes to your points this morning, is you don't need to get into this mess. There may be a right legislative solution for that, but I actually, and personal biases, but I think the problem that we have in a lot of these contexts is over-enforcement, not under-enforcement. That the problems that you have is that, and it's not over-enforcement of having companies properly regulated, it's over-enforcement of negative class actions that really don't help anybody. So I just don't see this as being the right way to go at all. There may be other ways to go that somebody who knows more about the securities laws and how the financial business works, but I just don't see litigation as being the way to solve it.
So back to the guy who horsed around with a car, affects the odometer on my car. He could be liable with common law, but when it comes to people fixing the books and so forth, even if it's someone they don't intentionally make the misrepresentations to the investors, no liability.
That's right. And I think that it's not to say that there isn't possible fraud here, right? I mean, you were talking earlier about the preemption, which I think is important, but remember it's preemption of, as I understand it, it's preemption of state securities laws issues. So if I win on the idea that there's no fraud here in connection with securities, I may not win on the idea that the fraud that was properly alleged wouldn't have been, if it survived under state law, wouldn't be allowed to be brought. In fact, you'd think that my argument would imply that the state law cause of action for fraud would still exist, as long as it's not a state cause of action for securities fraud. But see, that's my point. This doesn't involve securities at all. I mean, it only involves securities because Charter cooked its books. The transaction that occurred at arm's length here had to do with set-top boxes, and unless the securities laws preempt set-top box fraud, which I don't think they do, I think you have an argument here. To the extent that it does involve securities, then it's an aiding and abetting involving of securities, and that's what the SEC is for.
Just if there's an arm's length transaction, does it matter whether or not there is a plausible, innocent explanation for both parties' conduct? In other words, does it matter whether or not we can explain a innocent motivation on behalf of Charter?
I don't think it does. I think it helps, but again, the question, I think, is one of pleading, and I know that we can say that with heightened pleading, but the question is can you plead a plausible fraudulent purpose? And I think it's too easy to do that. So what you've got to do is protect against those sorts of cases in the legal system. So I think I agree with a lot of people this morning who are suggesting that there's got to be a better way of doing it. But because there's got to be a better way of doing it, I think that this is not the way to do it. And I think that the text of the statute and central bank really fall on the side of that outcome.
Yeah. Are you saying that my investor, if I'm a California investor, I can go into state court and sue SLUSA? It would not preempt me?
I don't think you could.
I could not. So I basically lost my remedy in state law,
Yeah.
and I'm going to lose my remedy in federal law.
Well, if you accept the fact that there's got to be a remedy, then I think you're right. I'm not convinced by the idea that we have to provide remedies. And that isn't to say that I don't sympathize with the people invested in Enron. It's just that the problem with often with the legal systems, people assume that, well, if someone's been harmed, we've got to fix it by giving them a remedy. And that works until you start thinking about all these other sort of collateral problems that it causes. And I just think in this case the collateral problems outweigh the ability to give that person a remedy, although there may be better solutions through legislative mechanisms that would help them do it.
Okay, were you getting ready to jump in?
I was going to say that the pleading requirement to plead particularized facts raising a strong inference of scienter as to each defendant is a very, very, very high burden for and high hurdle for plaintiffs to meet in securities cases, and it's going to screen out cases that lack merit, and also explains why cases that get past the pleading motions settle for substantial amounts. Now, in this particular case of Charter Communications, it happens that the amounts that Charter overpaid to Motorola and Scientific Atlanta were exactly equal to the amounts that they paid back for the advertising. Motorola would pay $10.8 million, and Scientific Atlanta would pay $6.73. So that, you know, if they were thinking ahead, they might have structured it a little bit different to make the numbers not match up quite like that. Also, the fact that they backdated documents to get the stuff past the accountants, get it past the auditors, suggests very strongly to my mind that there was intent to defraud in this case on the part of the vendors.
Question?
Yes, my question is for Mr. Isaacson, and I agree with you in discussing the 95 Act that clearly Congress, in passing this under any normal sort of construction of the statute, we would infer that they chose to accept the implied private right of action under 10b and 10b-5. What I'm curious about is why you don't similarly embrace a normal statutory construction and say, well, listen, Central Bank came out and they came out and said, listen, we're effectively overruling Central Bank and saying the SEC has this authority. Clearly Congress knows how to create and express private right of action, and yet they chose not to. Why is that not a persuasive argument in your mind?
It's not a persuasive argument because Central Bank involved a case where the defendant said nothing that was misleading, had no duty to say anything, and simply, you know, sat on its hands while it watched somebody else commit a fraud. Now, that was characterized as aiding and abetting in that case. Nobody contended that there was primary liability under Section 10b. I don't think Central Bank stands for the proposition that if you commit a manipulative and deceptive act that violates Section 10b, you can say, yes, but I'm immune to liability because it was also aiding and abetting the violation of another party. Aiding and abetting, the fact that the conduct that characterizes Section 10b might also aid and abet or assist another's violation doesn't make it a defense. I don't think Central Bank addresses this case where the defendant has in fact committed deceptive conduct. And in fact, what Central Bank says is that secondary actors may continue to be liable. We understand that most securities fraud cases are going to be complex, and they're going to involve bankers and lawyers and accountants and others. And if they engage in deceptive conduct, they're liable. That's what Central Bank says.
Just one point, because you probably had Richard Epstein make this point if he was talking the other day, but it seems to me that what's interesting about the Central Bank, although Mr. Isaacson's correct in terms of the distinctions, in Central Bank there was at least a presumption there that the bank maybe had an obligation, some form of, it was in a trustee relationship. I mean, it really is interesting that in that case we don't think that there's any obligation there. But here, where it really is third-party transactions, and when you think about it, when you say vendors, here we sort of think, well, 17 million, that seems a lot. But under this theory, we're basically saying that anybody that engaged in a transaction with the issuer, where they thought something was potentially fishy that might eventually make it out to the investing public, that imposes liability, regardless of what else comes into play. And it just seems like that really is a difference between Central Bank that actually cuts in favor of these cases being resolved.
To whom did that fiduciary duty run in Central Bank?
That's not to the investors, right?
That's right. In fact, did it not run to people who might have been benefited by the fraud that was alleged in that case?
Right, and that's true here in the sense that there's no fiduciary duty here from the vendors to the investors either, right?
No, but there's a duty not to take steps to deliberately create a misleading impression. That is fraud. And you don't need to have a pre-existing duty. The big argument against Passley versus Freeman, sorry to go back to the common law, in 1789, the defendant said, I wasn't in privity, I didn't have a contract, I had no duty when I said that the person who was in privity in the contract would be good for his credit. And the King's Bench said, tough. You don't have to have privity. You don't have to have a duty. The only duty that matters is that you can't mislead people deliberately. And that's the duty we're talking about here.
So do the shareholders of Britney Spears record label have a cause of action against Britney Spears if they allege that she has misrepresented the extent to which she's going to be able to rehabilitate her career and once again be a multi-whatever platinum or whatever selling recording artist, misrepresent the ability, her ability to be popular or family friendly or whatever it is that would result in her selling millions of albums. I mean, one could argue she has misrepresented that or perhaps, and if she really has a duty not to create a misleading impression.
And you think there's reasonable reliance on what Britney Spears has said?
Well, I mean, the question is whether or not the shareholders do, right? I mean, this is. I mean, we could think of all sorts of circumstances where public figures, and I picked Britney Spears because she's in the news, but where the financial health of a company is dependent in part upon the performance of single individuals, athletes, performers, and so on, who may, for a variety of reasons, do things to try and increase the perception that they, in fact, will be able to perform as they had in the past, and may, in fact, even engage in some misrepresentation. And I'm just wondering if that means that whatever else they may have done wrong, are they guilty of securities fraud? And therefore, can they be held liable by the shareholders of the parent companies?
Well, there are plenty of cases out there where a company makes misrepresentations about a product. Apple Computer Securities litigation dealt with misrepresentations about a disk drive. Hanen versus Data Products was misrepresentations about a printer. Now, misrepresentations about a product, if the company's product is the personality of somebody like Britney Spears, I suppose you could come up with an argument that is analogous, that it's sort of like a product fraud. In a case that you've hypothesized, it's hard for me to see that there's going to be reasonable reliance, but
she gets signed to another
that's something to argue about in another case. There's one thing that I would like to address, though, that I haven't touched on yet, and that's the argument that this just involves institutional investors taking money out of one pocket and putting it into the other, that there's no real loss here. Well, I think that there's a serious cost when the integrity of our markets and our price system are threatened. A man named Friedrich August von Hayek wrote an article called The Use of Knowledge in Society in 1945. He received the Nobel Prize for Economics in 1974, explaining how important the functioning of the price system is to our society and how important the functioning of the price system is to proper allocation in the society. When you've got fraud in our capital markets, you are interfering with that. And on the argument that institutional investors just take the money out of one pocket and put it in the other, when you're talking about securities cases because they're widely diversified and they benefit from fraud as often as they are injured by the fraud. In the Enron case, the regents of the University of California lost over $140 million. Credit Suisse and Merrill Lynch and the other professionals that were working with Enron took that money out of one pocket. Did they put it back in another pocket because they committed fraud in other cases that the regents supposedly benefited from? If they want to make that argument, I'd like to see them identify those frauds, please.
Other questions?
This is a question for Mr. Isaacson. Before central bank, there was a lot of case law on aiding and abetting and what aiding and abetting meant. And the case law focus was very much on I either was an aider and abetter or I wasn't. Because if you were an aider and abetter, you had the same liability as a primary violator. So there was relatively little case law on the line between being a primary violator and being an aider and abetter. My impression, and correct me if I'm wrong, is there's still not a ton of case law on the distinction between aiding and abetting and being a primary violator. As I listen to you, though, it seems to me that you're setting up an even finer distinction to be drawn. And that is a distinction, I take it you accept, at least for the sake of argument, that the central bank says that there's no aiding and abetting liability, but your position is that that doesn't foreclose other forms of secondary liability. Where would you draw the line then? What would be your test for what constitutes aiding and abetting where there's no liability versus other forms of secondary liability where there could be liability? And could you give us an example of a case in which you think there would be someone had aided and abetted but would not otherwise be liable? In other words, a case in which a vendor, for example, you might say, well, they aided and abetted, but that's all they did, so they're not going to be liable, versus your position here, which is, well, they did more than aiding and abetting. They deceived.
Well, the question basically is whether they engage in deception, a manipulative or deceptive act. Now, I'm not advocating secondary liability. I mean, central bank, it makes it very clear that there's secondary liability of control persons, and then it goes on to say that if you merely lend substantial assistance to somebody who violates Section 10b by committing deceptive acts, you're not liable for lending substantial assistance to the violator. So central bank is saying you might have done something that helped somebody who committed fraud, but if you didn't do something that was deceptive or misleading yourself, you merely lent substantial assistance to the violation of another, you're not liable.
Could you give me a for instance of substantial assistance that would not itself be deceptive?
Substantial assistance that would not itself be deceptive. Well, I suppose it would be the trust indenture or indenture trustee, central bank itself, when it sits on its hands and doesn't do anything. It could have insisted on an appraisal. It chose not to, for whatever reasons. Now, was choosing not to do something, not to do anything, not to make any statement, and not to violate any duty that it had to the market or shareholders, and not itself create a misleading impression, lend some substantial assistance to the defendant or to the company in that case? The argument was that yes, it did. Now, the case law had no reason to distinguish between aiding and abetting and the primary liability prior to central bank. There was a Fifth Circuit case, the name of which escapes me at the moment, which dealt with claims against an accounting firm. I believe DeLorean's company was involved in it in one way or another. And the opinion is set up in a way that it first analyzes whether the auditors could be primarily liable, and it says, yes, the elements of primary liability are present here. Section 2 is aiding and abetting, and they say, well, because the elements of primary liability are satisfied as to these auditors, surely they could be secondarily liable for aiding and abetting as well. The fact that you could characterize conduct that amounts to primary liability and a primary violation of Section 10b also as aiding and abetting in a case such as that doesn't mean that there's no liability. Aiding and abetting and primary liability overlap substantially. And it's, part of aiding and abetting liability that has no involvement in committing fraud that central bank says there's no liability for that.
I think there were some other questions in the front. Am I wrong? If there aren't any questions, I might have other questions. Let me see if I go for it, Ms. Said. I'm looking at my notes, and I may have asked all my questions.
This question's for Mr. Parrish. The Fifth Circuit in the Enron opinion was kind of reluctant to say, basically, we realize that our decision means that the folks who could have pulled the plug on Enron get to walk away. And it sounds to me that you're comfortable with that result. But just wanted to hear your thoughts on that.
Yeah, again, I mean, it's hard because I've never dealt into the Enron case at all, and I know that's somewhat of a dodge, but I think these cases you do have to look at the specific facts. I do think, Professor Bainbridge's hypothetical really highlights the difficulties in these areas, and it shows that there is a difficult question to be answered. What happens when you have a consultant or a lawyer that's actively engaged in trying to, get information out to the public that's going to deceive them? But to me, these cases this is not this case at all, and it just shows clearly the difference between what happens when you try to take a difficult area of the law, which I think Enron to some extent highlights, at least it's well publicized, to an area of the law that I don't think should be that difficult. And the idea of expanding liability to these third-party vendors is really just a bad idea, and it's not supported by the case law.
Mr. Isaacson, I'm wondering here, there is, many would argue that implied rights of action, at least today, are to be disfavored. That wasn't the case in the past. But if that's the case, and one were to take the presumption that the court should not expand causes of action or expand private rights of action where Congress has not done so, is it possible to argue that this case does not involve an expansion of existing liability under the securities law? I mean, you've given us lots of precedents in terms of general common law fraud, but are there really applicable precedents in securities fraud so that we could say, one could argue that this is not an expansion of liability?
Well, it's not an expansion of liability because it falls right within the language of Section 10b, which prohibits manipulative or deceptive conduct with respect to securities markets. And you've got the Solicitor General of the United States saying, yeah, it's misleading and it's a violation of 10b. And you've got all this case law that says that if there's a violation of 10b, there's a private cause of action. And you've got Congress in 1995 saying not only is there a private cause of action, but this is how plaintiffs prove it, plead it, this is how plaintiffs prove it, and this is how, in Section 21D, subsection F, this is how you allocate liability among the many participants in the scheme. Now, for the Supreme Court to say, no, we're not going to let Congress, determine how these things are done, is basically the position that is being argued for by those who say that the Supreme Court shouldn't recognize that liability.
Mr. Parrish, did you have a...
Well, I think the one thing I'd point out is I don't think we can really say that the SG says that in its brief that there's been a violation of 10b. What it says is it disagrees with the lower court on its interpretation of whether or not deceptive conduct is limited to sort of affirmative misrepresentations and whether it's oral conduct. They then drop a footnote, which is sort of an odd footnote in my opinion, that talks about, well, the in connection with comment wasn't really argued, and then the respondents file a supplemental brief that shows in fact it was, although you can argue as to how significant it was. So I don't think you'd want to, I think it's fair to say that the SG comes out in favor of saying that it thought that the Eighth Circuit was wrong. I think it's also fair to say that the SG comes out on the idea that there wasn't reliance here, but I don't think they take a clear position on whether 10b has been violated or not.
Question in the back?
Yes, Mr. Isaacson. In terms of your California Board of Regents example, and on Enron, clearly, as I said earlier in the earlier panel, there are cases of individual investors who might be harmed. But aren't some of these public pension fund examples in precisely these types of cases indicative of some of the problem with this area of law? And particularly what I'm thinking of here is not Enron but WorldCom, when the case against Citigroup was led by the New York State Public Employees Fund, and in fact that fund held a massive position in Citigroup, but it was given to plaintiffs' lawyers who'd been major contributors to the then comptroller Alan Hevesey's campaign.
Well, it seems to me that you're arguing with Congress's decision in the Private Securities Litigation Reform Act of 1995 to mandate that the district court appoint as the lead plaintiff the plaintiff that has the largest losses. I'm not going to argue with Congress's judgment on that point.
Okay, I think at this point I'm going to ask each of our debaters if they want to just give a 1 or 2 minute summation or bottom line of their arguments before we close, and we'll start with Mr. Isaacson.
Well, it's not so much a summation. I'd like to speak a little bit to consequences. We've spoken some about the consequences of either recognizing or not recognizing scheme liability. I think the consequences of not recognizing it are pretty darn clear. I think that with central bank, as it's construed by much of the defense bar, The Private Securities Litigation Reform Act of 1995, with its heightened pleading standards requiring particularized facts, raising a strong inference of scienter, of fraudulent intent with respect to each and every defendant in order to proceed against those defendants with the case, followed by the Securities Litigation Uniform Standards Act of 1998 that killed state court litigation. People in the securities markets thought they were off the hook. They thought they were no longer going to face liability in private securities suits as a practical matter. And for a while, some people thought that was how it was going to turn out. I work as an appellate litigator in the Ninth Circuit, and in one case after another, dismissals of securities cases were affirmed by the Ninth Circuit Court of Appeals. It wasn't until 2003 that they finally sustained one. With the appearance to many people, many market professionals, that they no longer faced private civil litigation in class actions, what did they do? Well, Enron tells you, WorldCom tells you, there was a binge of securities fraud such as we've never seen before. And I think that's exactly what you're going to get again if the United States Supreme Court rules that there's no liability for deliberately engaging in a scheme to defraud investors.
Mr. Parrish.
Yeah, I'd just say a couple of things. One, I think that under the position at least Mr. Isaacson's articulating is that you'd have to interpret central bank as basically leaving nothing but the smallest of small slithers of secondary aiding and abetting liability that isn't also principal liability that's directly actionable. So basically what that means is central bank doesn't really mean much at all under that view, and it also means that Congress really didn't need to take any action in 1995 when it did, because everyone could be prosecuted essentially under primary liability. I just don't think that was what happened in central bank. I don't think that's what Congress intended when it enacted any of the securities laws, and certainly not in 1995. And I think that, you know, this idea that there's been this dip which caused fraud, I just don't think that's happened. I think if you look at the statistics, there's been a huge growth in securities litigation, and it's being driven in large part by large plaintiffs' firms. And there's, I agree with Professor Painter, there's, you know, there's good plaintiffs' lawyers and there's bad, but the bad plaintiffs' lawyers are filling up a lot of the air right now. And I think that the best thing the court can do here is just continue to apply central bank. It's an easy decision. Apply central bank, look at the 1995 Act, and then just apply the plain text.
All right. Well, in closing, before we thank our panelists, I just want to make a few housekeeping comments. Again, as everyone already knows, this case will be argued before the Supreme Court this coming Tuesday. After the oral argument, once the oral argument transcript is available, which will be later that day, we will be updating the center website with additional materials, including some materials from our various panelists today. So be sure to check back to the center website for additional material and insight on this important case. I think we've gotten a sense of the important issues that are at stake here. The importance of this case is further underscored by the fact that though there were over 24 amicus briefs filed representing everybody from the Chamber of Commerce and Business Roundtable to the AARP, to the Council of Institutional Investors, to various unions and pension funds, and over 30 states as well. So clearly this is a case that many organizations and institutions think is highly important. I also once again wanted to thank all those that helped in putting this conference together, Dean Reuter and the folks at the Federalist Society, the AV staff that have made the webcast of this possible and run so smoothly, Alice Simon and Nancy Pratt-Canner, who were really indispensable in putting these programs together, and of course all of our panelists today. So please join me in thanking everyone that helped make this possible, and have a good weekend.